Hi, it's Helen Butler from Inspired People Solutions. Lovely to have you join Angela Olanda and I today as this podcast covers off things to do with the JobKeeper stimulus package. Just a friendly reminder that this podcast is general in nature and is not legal advice or intended to be interpreted as legal advice. We're happy to chat with you about your individual circumstances at any time and answer your specific inquiries as they relate to your business. So don't hesitate to reach out to Ange or myself on any HR issues that we can help you with. Again, this podcast is general in nature and we hope you enjoy and thank you for joining us. Take care. Hi everybody, it's Helen Butler here from Inspired People Solutions, and today I am joined with the gorgeous Angela Olanda from Zen HR Consulting as we try and unravel for you this JobKeeper stimulus package that has been passed through Parliament and will come into effect. Well, it's already come into effect. We've just had some new terms and conditions drop that I guess we wanted to run through some of the most frequently asked questions with you that we are getting from some of our clients to help bring some clarity to you as we all muddle through this time. So, Ange, hello. Thanks for joining us again.
Thanks, Helen. Thanks for having me.
No problem. The first thing I thought we should just run through is the eligibility criteria for businesses. And I guess for us, for Ange and I, the businesses that we deal with would fall into this category, that they're eligible businesses that have a turnover, an annual turnover of less than $1 billion, who self-assess that they have had a significant reduction in revenue, and that's 30% or more since 1 March 2020, and that's over a minimum 1 month period. How you self-assess that is you compare it to last year's BAS statement as at 1 March 2019. So if you have had that significant loss of revenue, then you are one of those businesses that is eligible for the JobKeeper payment packages. There's also a number of other different criteria which we'll put in the show notes, but this would cover off, we think, most of you who we provide advice to. One of the things Ange and I wanted to just mention to you too is business registration and employee registration. The ATO has popped up their links and pages where you have to go on and register to receive those payments and check your eligibility. So we'll put those links in the show notes for you as well. So get onto that sooner rather than later, because as soon as you put in your expression of interest or application for that, then that kicks in straight away for you. So Ange and I have been quite busy the last little week or so going through and trying to unravel what is the JobKeeper payment and what does that mean for you as businesses. So we've had some questions that have come up that we wanted to run past you. And I guess one of the first things that has come to mind is that if you've been a business that's been really proactive when you saw coronavirus coming, and you started rejigging your business plans, making alternative arrangements with your employees about whether it's working from home, reducing hours, and now the JobKeeper stimulus package has come into play, and you might have altered terms and conditions of an employment contract, or you've made people redundant. What now in that situation? So Ange and I wanted to run through a few things with you and talk to you about, well, if you want to rehire someone back, if you want to change terms and conditions, what happens here? So, Ange, did you want to take us through a few key points about changing conditions of employment, potentially rehiring people after they've come back or after you've made them redundant, and what are some of the issues around that?
Yeah, sure. So for many employers that will have been proactive when coronavirus really started hitting businesses, their revenue and income, in making changes to their employee terms, looking at their wage bills, particularly around varying terms and conditions in relation to hours of work, location of work, taking paid leave or unpaid leave, and things around looking at making roles redundant. With the JobKeeper scheme coming in, it has raised some questions around what happens now to those varied terms and conditions of employment. And let's talk about that first, and then I think we'll talk about redundancy next. So looking at the varied terms and conditions of employment, that after 1 March and before the government announced the JobKeeper scheme, employers will have made a lot of changes. And invariably, and if done correctly, the employee will have consented to those changes and, in fact, varying their terms and conditions of employment that may have prevailed in a previous employment contract. So what's happened is that the employees started their employment on, let's say, for example, 38 hours a week, full-time capacity. Coronavirus hit, employer needs to look at making changes to their workforce. And let's look at this pragmatically, whether it's coronavirus or maybe a lost big contract, and in an attempt to keep employees in roles, an employer would consult with their employees and say, look, would you be prepared to change your hours to part-time? And the employee saying yes, would agree to it. And then that would, in effect, create a variation of employment terms and conditions. So when the JobKeeper comes in, I don't foresee there being any need to go and revert those variations back to what they were prior to coronavirus, changes needed, if I could call it that. Yep. So therefore, how I would see it is that, yes, let's say they've gone to a part-time arrangement after 1 March, the JobKeeper payment comes through 30 March. The employee can remain on those terms until such time as they're either varied at a later point, hopefully they're increased and they revert back to a previous arrangement. We talked about these arrangements being temporary with regular reviews, so that they're temporary on a monthly basis, maybe a bi-monthly basis, until such time as, they're varied again. Helen, do you want to weigh in on that a little bit about the...
Yeah, I think one of the important things is that one thing that has come out of this JobKeeper stimulus package is that there cannot be a reduction in someone's hourly rate. So if you had a variation of your contract in terms of hours, say sometimes you might have gone from 8 hours a day to 6 hours a day in that 1 to 30 March, and you've varied the employee's terms and conditions with respect to hours, but their hourly rate must remain the same. So in effect, you have had a reduction in their salary, but the hourly rate remains the same. So I think there has been a genuine compromise, negotiation and consultation, and it's been put together in good faith, and that will stand you in good stead if anything were to come of that, with potential fair work, if there's been good consultation and you've followed all the processes that you usually have to follow and everything's been done well. Please make sure you have it in writing and it's been signed off on. So it's kind of like, I think we said in our first podcast, Ange, it's like an addendum to your contract. So with regular review. So I just think that's going to be really important for you to mitigate any risks in that respect. There is some conflicting advice about the terms and conditions of your employment as at 1 March, but I think everything in writing, if it's done in good faith and in consultation, it gets you out of a lot of mischief in that regard. So just
and with consent. So if it's
exactly
employee agrees to those changes free, upon their own free will, without being coerced or forced into making such a decision, that's right. It carries far less legal risk to the business.
Yeah. We spoke a little while ago as well, Ange, about redundancies as well and the impact that they have on business. And this opens up a whole new kettle of fish, the JobKeeper payment coming back in. What has been your experience with people, or what's your read on the situation if you've made people redundant but you want to rehire them now because this the JobKeeper payments have come in? What's been your take on that particular situation?
Yeah, I think for employers who have made some tough decisions to reduce their workforce and have to let go some highly trained, highly skilled, highly loyal employees, that would have been a very challenging time for them. So this JobKeeper arrangement enables employers to rehire those employees who have been made redundant if they want to do that. For employers who feel that they don't have the need for that role to be performed by anyone now or in the immediate future, they are quite within their rights to not decide to go and seek those employees to have them rehired. But on the notion of employees that are rehired, there are some concerns, some questions I have around that more than anything. I know hiring them back on a new employment contract, Helen, we talked about that, and that was your suggestion, a very good one, that they start clean under new arrangements. However, there has been some conjecture out there around the risk of unfair dismissal claims that might happen. So, when you're rehiring them, do you wait the 21 days if you feel that you might have some legal risk to that? We hope many employers followed the appropriate consultation processes that are contained within any relevant award, industrial instrument or national employment standards. But I also note that it was a pretty chaotic few weeks where employers were just scrambling to make ends meet and try and stop this leaky bucket from leaking anymore. So people may have acted hastily. I think we'll be yet to sort of see what transpires from some of those decisions. So, is there some protections or risk mitigation strategies employers can do now to protect themselves from that rehire or potential risk of unfair dismissal? A second issue there is around when they are rehired, they've effectively been paid out a severance pay, given notice, paid out their leave entitlements that are statutorily payable on termination, like annual leave or long service leave if they have an entitlement to that. What happens then? Does that get reimbursed? Does the employee get to keep that? Does the employer need to recredit the leave paid out? Is there an expectation of continuous employment? It's very murky. And I just think tread carefully with that and do seek specific advice, because your situation is going to be unique and it's going to be based on managing risk as well as what steps you took during the redundancy process and what steps you plan to take with that employee after rehiring them too.
Yeah, absolutely. I think you're spot on. Like I had a very specific incident where we were talking about this with a client, and I advised just wait until the 21 days is over and done with, because that's one thing that you don't want to have to deal with, bringing in your old employee in as a new employee and then they make an unfair dismissal claim. Just mitigate your risk and wait 21 days is, I think, the safest thing to do. But then I think the cleanest way to go is to just start a new employment contract, and you've paid out all their entitlements. Going back and recrediting all of that is just, it's one of those things that's tricky and a bit of a nightmare. But again, feel free to contact Angela or I to talk about your particular circumstance, so we can walk through what that would look like for you and give you your best scenarios, and then you can make an informed decision going forward from there. One of the other things, Ange, that I think we just wanted to cover off was superannuation as well, because there seems to be some conflicting advice coming around about, are superannuation entitlements having to be paid on JobKeeper or not? Are they paid on top-up? Did you want to talk us through what you think the right thing to do is, or what your interpretation of superannuation payments is at the moment?
I want to start by saying it is not clear cut for me, and I certainly do not want to be giving a definitive response to it. Everything I've researched on it, I have two different sides of the story, and through my research I've really discovered that there seems to be some overlooking in the amendments to the Fair Work Act, or through the changes of the COVID-19 Amendments Act. Forgive me, I don't have it handy with me to give the full name of it, but the JobKeeper scheme essentially. And super doesn't seem really clear cut, unfortunately. So is it payable on the $1,500 per fortnight JobKeeper scheme? Is it payable or not on any component that's paid above the JobKeeper payment? Is it not payable on the JobKeeper payment? And is it discretionary, and what elements of it are really clearly discretionary, and employer discretionary, whether they make the choice.
Yeah.
You know, Helen, you've got a view on that. I think that's the same.
I'm absolutely in the same boat as you, that I have looked at advices from law firms, from superannuation companies, and on the government website, and it is not clear cut, in my opinion, about, you know, if someone's earning $1,800 a fortnight and the JobKeeper subsidy allows you $1,500, on that $300 top up, you have to pay superannuation. It's just how it is. I don't think there should be any difference between someone still accruing their annual leave entitlements as well as their superannuation entitlements. So what I would be doing as an employer at the moment is just keeping that money aside and putting the full superannuation entitlement aside for your employees until we get a clear-cut decision on it, because you're better off having that put away, and they're entitled to those entitlements as they are annual leave, but it's not clear. So just put the money aside as part of your PAYG, your super, and your leave loading every single fortnight as well. And one of the other things to bear in mind as well with this JobKeeper payment is you have to pay your employees every fortnight. So you're going to have to, if you're doing a monthly or a weekly cycle of pay, you're going to have to rejig it. That's one of the things that's come out as well. So just bear that in mind. I would put your super aside just in case until we get some more clarity around that at the moment. But I'm sorry it's not clear, unfortunately.
I know. And I think, we talked about in our last podcast, some of these changes that have been introduced take decades to get agreement and done, and these have been turned around in a matter of weeks. So I think we will be probably identifying more so gaps within the mechanics of it, and erring on the side of being more generous and cautious is my motto with my clients when unsure about how to apply elements of the law or pay or anything really employment related, until you get that clarity, and then corrections can be made where you've been over accruals or adjustments made at a later stage. So definitely some good advice there, Helen.
So, and one of the other things that I really think is important to cover off, and we can have a bit of a chat around this, is standing down an employee or a job enabling direction, and what does that look like, and what does a business have to do with respect to, essentially this is asking an employee to vary the terms and conditions of their employment while the COVID-19 virus takes over. And I wanted to just be really clear with people about, well, what does a direction look like? And then we can talk about how we have worked on that in particular scenarios. But essentially what you need to know as an employer is how to give a direction. And there's three key elements to this. It's consultation with the employee, and an agreement has been reached to vary potentially the terms of their employment. You have to provide the employee with written notice and give them 3 days notice prior to the issuing of the direction, or a lesser period if they agree after the consultation. And the types of directions that an employer can give to an employee are standing down, which involves probably them not working and just staying at home because you don't have the work for them. Their duties of work can vary, their location of work can vary, days of work, and paid annual leave. So they're the types of directions and things that you can look at to vary under the job enabling direction or standing down. We will put up on the show notes as well details around how long does that direction last, etc., and how you go about doing it, and give you some templates as well that we've got available to us. But, Ange, did you want to talk us through some, I guess, where you've had this situation come up with you, and some examples or case studies of where you've had to give directions to and help out some of your clients?
Yeah, so thanks, Helen. So, what queries I've had is from employers is, I'm going to be eligible. I know I'm eligible for the JobKeeper scheme. I have my employees on stand down in accordance with the Fair Work Act. I want to bring them back to work on modified duties, so not performing the role that they were performing prior to their stand down, but doing other things. And I want to do that now.
Yeah.
Firstly, it can't be a JobKeeper enabling direction because they haven't qualified officially yet for the JobKeeper scheme.
Yeah.
So any direction that's given for a stand down to reduce their hours or days of work can't be given unless it's with consent from the employee. So and not only that, but to vary their duties as well. So let's say hypothetically they were qualified to receive the JobKeeper payment for an eligible employee, then they could provide a direction without needing an employee's consent, having consulted, and that the reasonableness of those requirements have been considered. We went through a consultation process with the employees. We documented those consultation processes and provided them in writing to those employees of those two factors of varying their hours of work and their duties, and it was subsequently signed. So when the JobKeeper scheme kicks in, it's really status quo. The $1,500 will be paid on a fortnightly basis, and there won't be a variation there because it's already been introduced. Interestingly enough, though, because strategically the hours were looked at being reduced to a fortnightly pattern so that they didn't equate to more than the $1,500 a fortnight. And again, that was obviously with consultation, the employees' consent. However, that probably wouldn't stop an employer who does qualify giving an eligible employee a direction to reduce their hours of work so that $1,500 is prevailing on a fortnightly basis at an absolute minimum of payments entitled to them. Consultation is really important. I wanted to touch on that very quickly. Some people aren't sure what consultation actually means. Consultation is having a conversation and presenting a proposed change to someone's terms and conditions of employment in the context of this, and giving them an opportunity to put forward their thoughts and concerns in relation to those changes, and importantly, the employer giving time to consider those concerns and thoughts in relation to those proposed changes. That's consultation, and that's got to be proven. So making sure that's documented is really important, and Helen and I can be contacted to talk about more specifically how that consultation can play out so that you are, as employers and businesses, ensuring that you're satisfying those requirements. It's interesting times, and step by step, day by day, we'll be learning more, and we'll be working with you on getting the best results that you can achieve through these schemes and to make your businesses viable going forward as possible.
And I think Ange and I both on our websites have got information for you. So if you Ange's website is zenhr.com.au and my website's inspiredpeople.com.au. If you would like to just go on there and have a look, and we've got fact sheets, we'll have information for you about what changes look like and how it can impact your business, and we're certainly here to help. So please do not hesitate to reach out to us. We can help you with all of your HR queries, your business planning right now, and what that looks like for you specifically with JobKeeper, but also start casting your mind to what your business is going to look like and what shape it will need to be when we start coming out of COVID and restrictions are starting to be lifted. We can help you plan and process for that, and we'll bring you some more podcasts in the next coming weeks about what's the path forward for you from a HR, a talent management, and also a risk management perspective as well. But first and foremost, let's get you through this time and get your people on JobKeeper and just retain the best staff you can. But one thing that we also just wanted to touch on from a business point of view is you can still operate, and if there's HR issues, if you need to make people redundant as the normal course of your duty, or there's performance management issues, we are here to guide you through that as well. And Angela's got extensive experience in that space, and we can both work with you to help you with any people issues, not just JobKeeper, but any people issues going forward.
Yeah, and I think that's still continuing in many workplaces. I know a lot of stuff's probably been overshadowed by the JobKeeper scheme and COVID-19, and understandably, I can understand why employers or business owners or managers and leaders are sort of turning their eye away from sort of the old day-to-day kind of run-of-the-mill kind of people issues. Yep. So, yes, Helen and I are here to help, and we want you to get through this the best way you can. And, yeah, so be in touch with us.
Yeah, beautiful. Well, thank you. Thanks for listening. We hope you enjoyed today's podcast, and we'll be back again, no doubt, in a week's time to give you some more information about what's been happening. Ange, thank you for your time.
Thanks, Helen. Thanks, everyone.